Welcome to the first podcast in this series of podcasts in Module 4, which is about the approach of the court to parenting cases. So this is in the context of where parents have separated. They need to work out arrangements for their children, where children live, the time they will spend with each parent. And as we said in the Family Dispute Resolution module, the emphasis is on assisting parents to have discussions and make their own agreements. However, even in those sorts of processes such as negotiation and mediation, it's helpful for family lawyers and also for family mediators to have an understanding of the legal background and legal concepts in this area and how the court approaches making decisions about children. Also, a small percentage of parents aren't able to come to an agreement and they need to go to court. So as a lawyer, we do in some cases need to make applications for people in court and end up at court hearings. So in this series of podcasts, we're going to talk about a concept called parental responsibility and what it means and what are the differing requirements between decisions about day-to-day issues relating to children and decisions about major long-term issues relating to children. We'll also explain what concepts such as equal shared parental responsibility mean and other terminology that's now used in family court, such as who the child lives with and who the child spends time and communicates with, which replace the old terms that were previously used initially, custody and access, and after that, residence and contact. So these are the current terms: who the child lives with and who the child spends time and communicates with. Then finally, we will look at how the court approaches these types of cases. We'll explain the key parenting sections and how the court uses those sections of the Family Law Act to make decisions in the best interests of. Now, the first area we're going to deal with are what we call preliminary matters, and what needs to be established for a party to be able to apply for a parenting order in a family court. And this is particularly relevant these days when not all of our clients are, for example, Australian citizens, and we are having a large number of people coming from other countries into Australia, some who become our clients and might need help in family law cases. So initially, if we're advising a client and we are looking at needing to go to court, and what do we need to establish first before we can go to court? Well, as we said in the Family Dispute Resolution module, in parenting cases, generally our parents or our client, being one of the parents, the mum or the dad, must attempt to attend family dispute resolution, which is in effect family mediation. Now, as we said, this is the general case. There are exceptions. We looked at the exceptions last module, and they're contained in section 60I, subsection 9. If they fall within the exceptions, we do file an application in court without attending family mediation, but we also need an affidavit in support as to why we fall within the exceptions, or to include that within our parenting affidavit. Now, if not within the exceptions, parents need to attend family mediation, or our parent needs to try and organise it with the family mediator. If it can be organised, they attend mediation. If they can sort out their issues, they might be able to write up an agreement that can be converted into a more formal agreement, and we'll be talking about that in the series in one of the podcasts this module. If they can't reach agreement, or if the other party won't attend, or if during the mediation the family mediator thinks mediation is not appropriate, They can issue the necessary certificate under section 60I8, and that's the certificate that we file in court. Now, when we're looking at filing in court, we'll see that under section 65B, the court's power to make a parenting order is contained in this section of the Family Law Act. So have a look at that section. Oh, I'm sorry, it was 65D. I'm not sure if I said D. So this section says, in proceedings for a parenting order, the court may, subject to section 61DA and 65DAB, make such parenting plan as it thinks proper. Now, that means the orders the court made are subject to applying the presumption of equal shared parental responsibility in section 61DA. Now, that won't make any sense at the moment, but it will by the end of this module. Also, any parenting order the court may make can be subject to a previous parenting plan if the court thinks that that's in the child's best interest. And what that means is, if you go into court and your parents have a parenting plan that they've entered into previously, that the court can have regard to the terms of that previous parenting plan if they think that's appropriate. Now, the types of issues that a court can deal with in relation to children are the persons with whom the child is to live, and sometimes an order is framed in terms of a child living with one parent. Sometimes it's framed in order in terms of them spending some time in relation to them living with both parents at different times of the week or month. The time they are to spend with parents or other significant others, such as grandparents, if that is relevant. The allocation of parental responsibility, which we'll see is decision making between parents about their children. The communication a child is to have with any other person, and also with their parents. So that would normally be when they're not with that particular parent, making a telephone call or a Skype, either the child to parent or parent to child, to stay in touch. Maintenance. Now, these days, children under 18 are generally, financial support for children is dealt with by the Child Support Agency, but under the Family Law Act, you can make an application for maintenance for a child who is 18 or over, and that might be relevant, for example, if they're studying at university, are unable to support themselves and the other parent won't agree to provide some support for them. Other types of issues that can be dealt with in a parenting order or even a parenting plan are arrangements for children, for example, what school they will attend, what religion they might be brought up in, that type of thing. So that gives you a bit of an idea of the types of issues that come up in discussions between parents and at mediation, and also the sorts of issues that courts can deal with. Now, who can apply for a parenting order? You'll see, and particularly if you read the relevant chapter of the text, this is dealt with in a bit of a detail. Either parent can make an application for a parenting order. A grandparent can, a child can, but I've actually never seen that happen, or any other person concerned with the care, welfare or development. And normally that would be a person who has had care for them. For example, a step-parent. So making an application for a parenting order isn't just limited to a biological parent. See also section 69C, and these are all sections of the Family Law Act, because these are the types of people who are also under the Act able to institute proceedings. That means file an application for a parenting order in a family court. Now, to apply for a parenting order, the child must be under 18, unmarried, and not in a de facto relationship. If there are parenting orders for a child or young person, it stops being enforced if the child turns 18, marries, or enters into a de facto relationship. Now, in practice, sometimes the court won't make orders for older children, for example, 15, 16, 17, but there's no particular age at when the court's power to make an order cuts out apart from 18. However, it is often acknowledged that older children might have strong views and might not be able to be forced into certain arrangements. Australia, there has to be some connection, and I guess this is the relevance of working with people who aren't Australian citizens. So if the child or parent is an Australian citizen, there is no problem. They can file an application. Apart from that, they must have been ordinarily resident in Australia or present in Australia on the date of filing. So have a look at that section. Now, in relation to which court to file in, all you need to know is that generally all applications go to the Federal Circuit Court of Australia, as that is the court that is considered to deal with most family law matters. Only more complex matters, such as serious allegations of child sexual abuse, might go to the family court, or complex property matters, because it is considered to be the court that has more complex cases. So that's all you need to know in relation to which court to file in. In relation to parenting proceedings, normally when you file an application in court, you will make an application and you have to decide whether you want interim and final orders or just interim orders. Now, in relation to final orders, it would probably take about 18 months to get a hearing date for final orders. That's why most people would also ask for interim orders. An interim order is an order until that final order is made by the court. Often people obtain interim orders and then that may be the end of the case, just because, for example, of cost, and the fact that in some cases, once an interim order is made in relation to children, it may be hard to change that, particularly if you're seeking then to change it so that the child has to, for example, move to a different place, move to a different school, because taking into account stability is very important for children. Now, the next podcast will be about parental responsibility. That is, about parents making decisions for their children.